Welcome, my name is Mitch Edelman. I'm the Jackson District Supervisor for the Remediation Division of the Department of Environmental Quality. And with me tonight is Sybil Cohen, the State Project Manager for the Gelman site. He also works for the Remediation Division out of Jackson. And in the back is Brad Werfel, the DEQ Press Secretary, works out of Lansing. Before we go any further, well, I want to mention that we did invite Pall-Life Sciences to participate in the meeting tonight, and they chose not to participate. Before we go forward with the presentation, I'd like to take this opportunity to introduce in the audience state and local elected officials who are here. I know we have a representative from Senator Warren's office, Sarah Kermey. Sarah, can you please stand and say hi?
Hi, everybody.
I know Mike Moran is here from Ann Arbor Township, Ann Arbor Township Supervisor. Do we have any other elected officials that want to stand up and introduce themselves?
Mike Gaglin's here.
I'm Mike Gaglin, the ward representative.
And
Okay, thank you very much. Anyone else?
what was that last name? Stephen Pondolo.
Also, we've got there's a group called the Coalition for Action on Remediation of 1,4-Dioxane, or the CARD group. It's a group composed of representatives of local units of government and interested local citizens. And I know we've got several members present from the CARD group, and I'm going to call on some people that I recognize initially, and then ask anybody else that I might have missed to stand up. So Mike Moran participates in the meetings and the CARD regularly. Again, with Ann Arbor Township. Mike Gebhardt with the WASHTENAW County. Matt Dodd with the City of Ann Arbor. Where's Matt? Here. Okay, Roger Rail, of course, with SIA Residents for Safe Water. Anyone else?
Larry Lemke's right here.
Dr. Lemke is a participant on a technical work group that the CARD participates in.
Patty
Who else am I
Benson's,
missing?
Patty Benson's here.
Patty Benson, longtime activist with SIA Residents for Safe Water. Okay, thanks everybody. Oh, Vince Caruso and Dr. Rita Lott Caruso just entered. They're also participants in the CARD, Coalition for Action on Remediation Diocese. Before I turn it over to Sybil to talk about a few things, I just wanted to acknowledge up front that both the staff of the DEQ as well as our management recognize and understand that there's probably a lot of people that are frustrated with the fact that we modified the consent judgment to allow for an expansion of the Prohibition Zone, among other things. And I don't expect anything I say or do tonight is going to alleviate your anger or frustration, yet I ask you to please consider that the actions that we took were really required under state law. We're going to highlight, for those of you that were at the public meeting that we had in May of 2009, we talked about Pall-Life Sciences' proposed plan, compared it to parts of the statute and rules that we use as a measuring stick for these things, and we're going to talk a little bit about that tonight, particularly a section of Part 201 of the Natural Resources and Environmental Protection Act that really requires us to look at proposed modifications by people that are a party to a legally enforceable agreement and what the department has to do under those circumstances. So really, I think the court's imposition of the Prohibition Zone, which is viewed as an institutional control under Part 201 in 2004, really opened the door up for the amendments that we're here to discuss tonight. So please bear that in mind as we move through, and we're going to, Sybil and I are going to go back and forth covering the modifications, a little bit of the history, and how the liable party Pall-Life Sciences obligations have changed as a result of the modifications, and then we're going to have time for questions, and hopefully we'll have some answers for you. So with that, I'll turn it over to Sybil.
Thank you, Mitch. Again, I'm Sybil Cohen, and I am the project manager for the Gelman Sciences site. I just wanted to give you, for those of you who might be, I guess one of the questions we were wondering, are there new people here who haven't been coming to any of these meetings? Just curious. I recognize, obviously, a lot of you.
We haven't notified of anything, so how would you know?
Well, we had, there was a legal notice published in the paper. I do maintain an email distribution list, and we maintain a website where we've been posting all of our information, and you can see how to get there on the board here.
But if you don't know something's happening, why would we even go there?
Well, I guess I can't, we are not required to notify residents individually about this change.
Not required. Not even a courtesy.
Well, it is a large area. I don't
It
know.
doesn't look that big to me.
Okay.
Well, Sybil's going to talk about,
You might need a microphone.
The
Sybil's gonna-
microphone is not working, so I will speak up. I can speak up.
and Sybil's going to talk about ways for people that haven't been involved in getting information about the site, ways people can get information about the site. We've got a mailing list that she maintains, and we'll make
Kind
sure
of
that-
late now, it's done. It's a done deal.
Well, you're going to find out that the response activities that are going to be going on, or that are going on at the site, are going to be taking place for tens of years into the future. So if you've got any long-term interest, we'd be more than happy to add you to our mailing list, refer you to our website and other.
Email distribution list. Basically, we maintain information repositories, and currently those are at the downtown Ann Arbor District Library, as well as at WASHTENAW County Zeke Road office. Previously, we made hard copies periodically. We would send those documents out and make those available to the public. They're also available at our office in Jackson, but obviously that's not very convenient. But about 5 years ago, we began putting all of the documents online on our Gelman Sciences website, where it's easily accessible for those who have a computer, obviously. And I also maintain an email distribution list, which I inform people who are on that list about this meeting tonight and about new documents that we post periodically, which there was additional ones posted in the past week or so that I sent a notice out about today. So if you're interested in getting on that list, if you sign in, and we ask that you sign in just so we can document the interest of people in this site here tonight. And if you want to be added to the email distribution list that I maintain, if you have an email address, you can put that on there, and I will add you to that list, and we will keep you informed of things going forward. We're also working on an updated information bulletin with details about these recent changes. We hadn't been able to get that completed in time for the meeting tonight. We'll be making that available, probably hard copies locally as well as available through our website. So I guess with that, I'm going to turn it back over to Mitch.
Okay, thanks, Sybil. I briefly wanted to talk, take a minute to talk about the authority that we have and our role in this site. So the DEQ was most recently established by executive order under Governor Snyder this past January.
It will only come up to this one.
Governor Snyder issued an executive order this past January that took effect March 13th that reestablished the Department of Environmental Quality. We were for about a year, Department of Natural Resources and Environment combined. So before that, DEQ existed for about 15 years. And DEQ takes care of the environmental stuff, air, water, waste, and pollution prevention activities. And of course, Natural Resources is more the fur and fish and game regulations, etc. We administer, among other things, Part 201, which is shorthand for there's the Environmental Code, which is legally known as the Natural Resources and Environmental Protection Act, which is Public Act 451 of 1994 as amended. Part 201 is the environmental remediation part of that code. We administer that, and I'll highlight a couple other things my division does on the next slide. An important thing to note about Part 201 is it's a risk-based remediation program. I used to say, when people ask me what I do for a living, I work on helping clean up hazardous waste sites. The way, I've worked for the department now a little over 26 years, the way the pendulum has swung over time, we've gone from basically a cleanup program that started in 1982, modeled after the 1980 Superfund law that called for cleanups of sites that have hazardous substance contamination to levels of background for naturally occurring compounds such as arsenic and lead, to a detection limit driven cleanup program for man-made chemicals like the one we got here, 1,4-dioxane and benzene, for example. The way it is now, especially since the 1995 amendments to Part 201, we're a risk-based program based on land use. And some of the ways to reduce that risk include cleaning things up in the traditional way that you or I might think of, digging up contaminated soil, pumping and treating contaminated groundwater. There are other avenues available to people who are liable for contamination. And the way the law is structured, if we've got a liable party and they propose a remedy that complies with the law, we're obligated to accept that remedy. So we're oftentimes engaged in evaluating people's proposals as to how they're going to manage the risk at their sites. So we'll cover a little bit more of the history about how that's translated for people that have been involved in this site, you know, like Roger and Patty and company. You know, I think they certainly know as well as many the changes that have derived from the legislative changes as it relates to this site. Okay, next, our current director, Dan Wine, has articulated the principles for the DEQ that we work for now. And that includes being leaders in environmental stewardship, being full partners in Michigan's economic development, and excelling at custom.
Where's that site in Public Meeting?
Being full partners in Michigan's economic development?
Yeah.
Well, for example, we work in the Remediation Division. We're involved in redeveloping of what I call recycling sites of contamination. The goal being to target development at sites that are at brownfield sites. Are you familiar with that term? Versus greenfield sites. So we work under the tax increment financing law with developers. We work with other parties to collaborate and not be obstacles to redevelopment at the same time as balancing our role as environmental stewards. And it's a tough job, but hey, you know, it's one that I chose to do and I'm passionate about it. Okay. We're also, next one, please. One of the overarching concerns in Part 201 is that we're responsible for protecting public health, safety, welfare, and the environment. How that looks at different sites might not appear as how that we're actually doing that, but again, being a risk-based program, if we can control, or if a party that's responsible for contamination can control exposure so that there isn't an exposure, that is an element of managing risk. And we also oversee compliance with this consent judgment as well as other sites throughout the state. Now I'm going to briefly do a digression because I've got a captive audience, so to speak. I want the next slide, please. I want to talk briefly about some of the other things that the Remediation Division is involved in. Because a lot of people that we in Civil and I interact with on this site only deal with us on this site. And I wanted to take a chance to explain that we work on leaking underground storage tank sites, which is part of Part 213 of the Environmental Code. We oversee and work with other liable parties at other Part 201 sites, and this orphan site thing is, I remember I mentioned the 1995 changes to the cleanup law of Part 201. That, one of the changes that occurred was to the liability scheme, and now the Department of Environmental Quality has the burden of showing that somebody's responsible for an activity causing a release of hazardous substances. So that opens the door up where we can't meet that burden to have a contaminated site out there that needs the risk addressed somehow. And in the past, we've had the ability to use money that's primarily been derived from two voter-approved statewide voter referendums, one in 1988, one in 1998, that we used in part to help sometimes clean up sites and sometimes manage the risk at sites. And we're basically out of money for that. So we do have a funding source for some of the leaking underground storage tanks, and that's called the Refined Petroleum Fund. It's funded by a 7/8 cent per gallon fee on refined petroleum. Briefly on the 213 side of thing, I've got some stats I wanted to share with you to show that we do other things besides Gelman. In Washtenaw County, we've had 866 leaking underground storage tank sites that have been closed. And I think I said in Washtenaw County. I meant to say in the Jackson District, which covers a 5-county area: Washtenaw, Jackson, Hillsdale, Lenawee, and Monroe counties. So we've closed 866 facilities. We've got another 504 open facilities in our district. 138 of those are in Washtenaw County. 49 are in our on the state-funded or the orphan side of things in Washtenaw County. We're currently working on 6 state-funded sites where we're doing things like pumping and treating contaminated groundwater and things like that. One of which is in Ann Arbor, and that's called the Arbor Wash site. On the 201 side of things, there's a former dry cleaner site right near downtown called Arbor Cleaners. It's a site contaminated with perchloroethylene, a dry cleaning solvent. We've also done some state cleanup at the town of solvent site. I mentioned the redevelopment component earlier. A recent example of that is some tax increment financing that we get involved in, got involved in on the Aldi redevelopment and on Maple and Dexter. So that's a little bit of a snapshot of other things that we're involved with besides Gelman. Next slide.
The next slide is me. I was going to do the review.
Okay.
So I'm just going to briefly try to orient everyone who may not be as familiar with the site. Here we have an aerial photo of the red line here is the western edge of the original Prohibition Zone. We'll talk about that a little bit more, but that's Wagner Road, and this shaded area here is the Pall Life Sciences, previously Gelman Sciences. Pall Life Sciences is the successor to Gelman Sciences. They began operating, and we did have slides to go through this. It was going to take us all night just to give you the history, so we're just trying to give you a little bit of an idea, and we'll cover some more details as we go when we get into some of your questions later, but we wanted to try to leave as much time as we could for your questions. So Pall Life Sciences used 1,4-dioxane in their manufacturing process starting in 1966 to make medical filters. 1,4-dioxane is a solvent that is completely water soluble. In their production, they produced huge quantities of processed wastewater that were discharged. A lot of the releases were actually permitted by the old DNR, and because 1,4-dioxane does break down somewhat if it's in a surface water and it's exposed to sunlight. But once it gets into the groundwater, it does not degrade to any significant extent, and it's made up of carbon, hydrogen, and oxygen, but it's held together by very strong bonds. So what happened, basically, we're in a very complex geological setting, and the groundwater leached into the ground and down into the deeper aquifers, and I'll show you a picture of the plume in a minute. And then because of the complex geology, it actually spread out in several directions. So maybe the next slide. Although, I'm sorry. Well, I just wanted to point out Honey Creek and the other. Sorry. Okay, so this is the tributary to Honey Creek here, and then, like I said, we have Saginaw Forest, and that has been impacted. So, okay, now we can go to the next slide. This is a general aerial of the entire plume. And so the peak that you see here, I should start out here. This darker red is the shallowest aquifer and the most contaminated. It was originally the most contaminated, and the dioxane ended up moving downward and spreading with the groundwater into this deeper aquifer here. Some of it also migrated off the south to the northwest. And then the deeper plume, the deepest plume, which is shown in pink, we had thought for many years was protected by a thick clay layer from the contamination higher up, and we discovered later that was not the case. Here we have the Huron River, and right up here is the Barton Pond is right up in this area, and the city's water supply intake is right where Barton Pond feeds back into the Huron River proper. And we'll have another slide here, but this Honey Creek flows over here and goes off the map and then comes back and it gets into the river somewhere off this map, but we'll show you some other slides. So again, the red is the solid red line is the original Prohibition Zone established in 2005, and the dashed one is the one that has just been established by this new amendment. And we'll talk about those in a little more detail. Next slide. And here we have basically a street map of, now this slide is showing the plumes all combined because we're now kind of treating the plumes in a legal sense. Doesn't matter what depth it is. Technically, and there is work continuing to go on here. There's been extraction, treatment, and discharge starting continuously since 1997. And Paul has a treatment plant back at the facility where they treat the dioxane with, previously they used ultraviolet light and hydrogen peroxide, and then they had a discharge permit from the Water Bureau of the DEQ, and they are currently discharging into the Honey Creek tributary at, they have to meet a monthly average of 7 parts per billion of 1,4-dioxane. So their influent coming in 10 years ago was in the neighborhood of 4,000 or 5,000 parts per billion. They would treat it down to less than 10 parts per billion. When the permit was reissued a year or so ago, the limit was lowered to 7 parts per billion. And the influent coming in from all the extraction wells that they have now is down to in the neighborhood of 500 parts per billion. So they have extracted and treated a large amount of mass and destroyed it with that treatment process. And then there's a small amount that is left over that does get discharged to the Honey Creek tributary. And I think that's a very general, brief overview. We can go into more details. Mitch, I don't know if you think I missed anything important.
I think it was a good overview.
Okay.
And we'll see, I think there's going to be more questions.
Yeah. Well, I just wanted to orient you, and I think at this point I'm going to turn it back over to Mitch.
Thanks, Sybil. Okay, I mentioned earlier this provision in Part 201 that I referred to as Section 2A. And that requires that the department approve changes to legal requirements, legal agreements, excuse me, such as consent judgment that Gelman had with us, that meet requirements of Part 201 upon the request of the party, subject to the legal agreement, with the overall proviso that any changes need to be protected from public health, safety, and welfare of the environment. And I'll give you next slide is the actual language from the section. It's all under the subsection 1, notwithstanding any other provision of the part, etc. The key thing here that it was a major factor in our actions relative to the modifications is, regardless of what that one says above, on request of a person implementing a response activity, the department shall approve changes in a plan for response activity to be consistent with sections 18 and 28. Now, 18 talks about the administrative requirements of remedial actions, and 28 contains the cleanup criteria, which are land use based criteria that were most recently amended in December of 2010. We used to have several different categories of land use based cleanups, those being residential, industrial, commercial. As of the December 2010 amendments, we've gone to two categories: residential and non-residential. Okay. Next one, please. Recall that in May of 2009, Sybil and I were in the city talking to many of you about the proposal that Paul had made to modify their agreement. And we talked about the criteria we're going to use to evaluate that. We talked about the preliminary district recommendation, i.e. the Jackson district that Sybil and I worked for, realizing that after we took the public comment that we took in May 2009, we were going to go to our management in Lansing and consult with them to reach an overall decision on whether to approve or deny the proposal that Paul put forward. So this is a slide from that 2009 meeting, basically summarizing the deficiencies that we had identified in the proposal that Paul had put forward. We thought they didn't have sufficient monitoring, they didn't have a contingency plan, and that was especially relevant to the area that we're talking about, expanding the Prohibition Zone. Well, this from this line up to here is this expanded Prohibition Zone. And Barton Pond, as Sybil mentioned, is the city's, provides about 80% of the city of Ann Arbor's water. We shared the concerns of the citizens that we don't want that to get contaminated. So a lot of those concerns related to protection of Barton Pond. But we also had uncertainty about the extent of the contamination. And 85 parts per billion is our current cleanup criterion for the contaminant concern here. And we concluded that the proposed plan lacked sufficient detail to be either conditionally or unconditionally approved, and therefore was denied. Now, I said this is the exact same slide we had at the meeting. I misspoke. Our slide in 2009 was just couched in terms of the Jackson District recommendation, but that was ultimately, we issued a denial of Paul's proposal in June of 2009, so that became the recommendation of the division. After that time, after our denial in June, let's go to this. Paul filed a motion in court to get the court to approve the proposal that we denied. We had a long history of involvement in litigation with the court at this site, and frankly, some of the rulings haven't been quite favorable to us. So we had to take a calculated decision and see whether we could come away with a remedy that would be protective of public health, safety, welfare, and the environment by negotiating with Paul versus going to court and fighting about it and having the judge issue another order. So we had some critical concerns that I've listed up here during the course of those negotiations. Again, it was assuring protection of Barton Pond and nearby residential wells, because in this Prohibition Zone, we already know that there's at least 6 residents that are not hooked up to municipal water. They rely on their own residential well. And one of the deals with this Prohibition Zone that the judge imposed, recall the judge did this, the DEQ did not advocate for it, was that it restricts the use of groundwater very drastically, with a few minor exceptions. Those exceptions include things like closed-loop heat pump systems, EV water, and a few other things. So residential well protection here, and protection of Barton Pond. We also knew, as did the representatives of CARD and other stakeholders that EPA, the U.S. Environmental Protection Agency, changed some toxicological information about the contaminant 1,4-dioxane. And they changed it, I think they increased the cancer slope factor, if that Dr. Caruso could speak to that if there's questions about it, because I'm not an expert in toxicology. But it could result, essentially, it could result in the lowering of that drinking water criteria, cleanup criteria that I mentioned earlier, the 85 part per billion one. I should have pointed this out when I had the section 2A slide on there, but it might have been obvious to some people when you read it. It didn't say that if the criterion changes downward, the department can go ahead and impose that on somebody with whom we have a legally enforceable agreement. I've tried to read it many times that way and not been successful. So basically, we call it, that section 2A is a provision for a party that's responding to a legally enforceable agreement to petition the department to avail themselves of current cleanup standards. Now, if the cleanup standard for dioxane goes down, Paul could petition us to clean up to that. I don't find it likely that they're going to do that on their own. So one of the concerns we had is potential lowering of criterion, so we'll talk about how we address that in the amendments to the agreement. Obviously, protection of public health, safety, and welfare of the environment. Enforceability was another concern we had, and that really stems from the 2004 amendments, which was the first time the court imposed this prohibition zone on, again, this is Wagner Road.
2004 Unity Order?
Unity Order, thanks for the clarification. 2004 Unity Order is where the court establishes prohibition zone east of Maple Road, or excuse me, east of Wagner, this is Wagner Road. And the conceptual model at the time the court issued that, as Sybil mentioned earlier, was that we had separate shallow and deep aquifer contamination over here, and then some of the earlier provision of the consent judgment had a non-expansion objective, and what we ended up finding out is the shallow and the deep stuff were likely commingled, and it really was difficult for the department in a regulatory capacity to differentiate some of these things based on the old classification of the aquifer. So enforceability was one of the reasons we got into this, and then financial assurance was another concern, and we'll talk about how we address that in modifications. And with that, I think it's Sybil's turn to get into what was and what is.
Okay, so we tried to simplify this as much as we could in a table format. So we have the systems that were originally established in the original consent judgment in 1992, and these are just the groundwater systems. There were some on-site property issues that we're not discussing too much at the moment, but have been source areas and are being addressed. The Evergreen, we call the Evergreen plume, basically, I think I need the next slide. There we go, okay. Now this is a close-up of all of the plumes, and again, this darker red is the core, which is the shallowest aquifer that was originally contaminated when the releases were initially occurring. And then there's interconnections with this intermediate depth plume, which we call the Evergreen or the D2 aquifer plume. And once that shallower contamination went into that deeper plume, it started migrating to the northeast into the Evergreen subdivision. And in 1989, homes in this area were found to be contaminated with 1,4-dioxane, and that area was hooked up to city water. And then again in 2001, we determined that the deeper aquifer, the deepest aquifer, we call the UV, which is kind of lavender in this slide, was actually contaminated, and the company started doing more investigation. Not all of these, there's monitoring wells shown on this slide, but they're actually not all there. There's several more in the Evergreen subdivision that aren't shown. Now this interplay right here, this interaction here, is where we think the intermediate Evergreen plume is actually connected to the deeper Unit E plume. And under the consent judgment, the company was required to fully clean up the Evergreen plume, the core plume, and the western area. I have another slide for that, we'll get to in a minute. And the Unit E plume was not covered in the original consent judgment because it wasn't believed to be contaminated. That was addressed in 2004 with the Unit E order, which established the Prohibition Zone. And I just wanted to, for those of you who aren't familiar, we went through a public meeting process in 2004. Pall-Life Sciences had done a feasibility study and analyzed different ways that this plume could be addressed because it was obviously a large problem that was not going to be easy to address. And the company proposed purging at Wagner Road, purging and treatment, which they're currently doing, as well as at Maple Road, and then allowing the rest of the plume that was east of Maple Road to continue migrating, and then, but to address this whole area east of Wagner Road with this Prohibition Zone that would, which is a legally required, in order to, as Mitch was discussing earlier, to avoid anybody being exposed to this contamination. Part 201 requires a legal method to prevent people from being able to use that groundwater. And since we're talking about the city of Ann Arbor, by and large, everybody in the city is already connected to the city water. So there's, so as long as you could legally prevent people from using that groundwater, then it would be allowed under Part 201. DEQ did not support that position, and in fact, the DEQ recommended that there be a leading edge purge system. That would require pipelines and extraction wells and more monitoring wells. And in fact, I believe we got several hundred signatures on petitions that were submitted of people in those neighborhoods who did not want that disruption in their neighborhood. And the judge ended up going along with Paul's proposal.
Sure.
Although originally Paul wanted to rely on the county. The county has a well regulation. They have the authority to issue permits, as Mike Gebhardt can tell you. And we did not feel that that in itself was adequate to legally restrict the use of groundwater. So the judge in December of 2004 said, well, because we had, as part of our decision, we said, well, Paul's proposal could be implemented with some additional conditions. One of those was a more certain way of eliminating the risk of exposure to drinking water. And so he basically directed the parties to go forward and come up with an order that he could sign that would legally restrict the use of groundwater. And that included, and that was how the Prohibition Zone was established in 2005. And we required as part of that a well identification process to try to make sure that there were no wells remaining in use in this area. And they did uncover a few wells that were plugged. There were very few homes that, and a business, I believe, that did have drinking water wells. They were hooked up to city water, and those wells were plugged. So, okay, so the new consent judgment, the third amendment, and there have been a couple other amendments, which I don't think we need to go into that level of detail right now. I can try to answer those questions later if there are any. But so we go from a full cleanup because again, the problem here was that although this portion of the plume is somewhat shallower than the deeper portion, we knew, as they did more investigation, we determined that there were actually interconnections between these plumes, and it was very difficult to clean up this area when you don't have to clean up this area. And so back in about 2007, the company started exploring options to expand the Prohibition Zone. And it's taken us a few years to get this far. And ultimately, that is the decision that was made. And so this area now will have a well identification survey process that will happen in the near future. And again, there's 6 homes that we know of that are on city water. 4 of those are at non-detect, and they've been monitored through the DEQ, and the county actually implements the, collects the samples. 4 of those that remain non-detect. One of them recently has been at a few parts per billion, and another home on Allison has actually been in the 12 to 15 parts per billion range. But that is below our criterion, so we're not able to require Paul to hook those homes up to city water because they. But now that home will be hooked up to city water.
What's the time frame?
Well, I believe the company has initiated with the city to get that process moving. But I'm not, this order was signed about on March 8th, so I haven't heard any specifics, but my understanding is they have started to take steps to get that done. We'll be working on the well ID survey.
What exactly is involved in this well identification?
Well,
Let's repeat the question, because
yes,
people in the
right.
back might.
The question is what's involved in the well identification process, and I can get into that now. I mean, we do want to get into it at some point. So we know that particularly the homes that are west of Maple Road, those neighborhoods were built in Ann Arbor Township when there was no city water available and there was
You mean
no
SIO, right?
requirement. And SIO, I'm sorry, right. I apologize. I always forget. The Ann Arbor Township is to the east of Maple Road and SIO Township is to the west of Maple Road. In any case, those subdivisions were platted in the 1920s for the most part, and homes were built in the 30s and 40s, and I'm sure there are more recent homes that were probably hooked up to city water when they were built. But basically, the company has to determine if the home was built at a time when there was no water supply, or they weren't required to be on the water supply because they were in the township, then the company is going to survey those properties, ask the property owners if they know of any wells that are in use, and we'll offer to inspect their properties for them. And then our desire is, if we can find any of those wells, we'd like to get them plugged to make sure that nobody uses them. Now, we know in this area here, where we did have that impact for a number of years, there were people who were hooked to city water and they kept their wells for irrigation. And we're going to do our best to find all of those. And nobody's going to be, there's not going to be anybody coming and forcing people to, we're going to inspect your whole property. But we want people to voluntarily, provide information that they have so that we can identify them. Yes, I'm sorry, the company Pall-Gelman Sciences. Yes, it's their responsibility to undertake this, and I'm overseeing it, and I've been very involved in the other process, and it hasn't always gone quite as smoothly as I would like, but yes.
I assume that what they're doing today is fully monitored in terms of them dumping anything new.
Can you speak up?
I'll repeat the question, but
I'm kind of worried that, are you monitoring all the other activities to make sure they're not putting anything else in the water?
the company, you mean, Pall-Gelman Sciences? Well, and I should mention, the question, yeah, go ahead.
To paraphrase the question was, is the company required to still monitor.
Are you monitoring their activities to make sure they don't do anything else in the water?
Is DEQ continuing to monitor Paul Life Sciences to make sure that they are continuing to discharge contaminants into the groundwater?
Yes, I mean, in 1986, when it was discovered, well contamination was first discovered in late 1985. And in 1986, the company stopped using 1,4-dioxane. And in fact, they're no longer manufacturing at that location. So, to our knowledge, they are complying with environmental laws. Now,
Well,
go ahead.
one point about the well examination. We had a case where a well was being used unbeknownst to most people and was contaminating part of the community.
The
So
Webbers,
yeah.
yes.
So that's an example where we want to know where the wells are.
Right.
And we don't want them
I
used.
could go into that.
You can just say briefly what happened with that.
Can we, Vince Caruso brought up a good point about the discovery of a well after the court imposed the original Prohibition Zone that was contaminated that Paul should have known about and should have paid to abandon. And we didn't find out about it until after the city found some contamination in some surface water and traced it back to the use of that well. So that's,
Shut the well off.
Yes.
it's important that we understand as many wells as possible are out there so that we can get to the goal of eliminating exposure. And I'm going to ask people, we're just about done with the presentation. Can we hold off questions until we're done?
Who's going to pay to plug the well if you've got one on your property?
Question is, who pays to abandon and plug the wells if it's necessary to abandon and plug the well? That's Paul Life Sciences' obligation to do so.
That is our position. There is somewhat of a disagreement about that. If in the case where we have the 6 homes that are currently using those wells, they fully recognize that it is their obligation to plug those wells. Now, there is in the well code, I can't cite the actual law, but the phrase abandonment is used in terms of a well is considered abandoned if it hasn't been used for a year or 2 years, or I don't know what the, so Paul has taken a position at some time that, well, those wells are not being used, and so we're not required to plug them. Now, so far, all of those kind of wells that we have used, Paul has agreed to plug those wells. And we are going to, if we find more of those wells, which I expect that we will in this expanded area, we will be asking the company to plug those wells, and we hope that we won't have to go to court about that. So, maybe if I can just try to get, I can talk more about the Prohibition Zone and the well identification issues, because I know that's of interest, but maybe I can get through the rest of this, and then we can open it up to questions.
Next.
Let's see. So, yes, I think I've explained the Evergreen and how difficult that was, and the reason that we were not, I mean, yes, we had concerns about, as Mitch was saying, we'll have another slide on here that shows Barton Pond, but we have done studies. The company, there's more wells along here that you don't see. They've actually installed 3 more in the past few months on the border. All of those have come back non-detect. They've set wells at 3 depths at each location, and they've all been non-detect. Of course, they're just installed, and we're going to keep monitoring those trends, and we're going to be finding out more to verify what the company has been saying and what the studies have shown. And I'm not a geologist, but we have our geologists looking at this information, that the contamination is going to flow east into the larger part of the original Prohibition Zone. But we believe we have gotten adequate monitoring to ensure that we can detect any migration that might possibly start going up towards Barton Pond. There's plenty of time that we would be able to address that concern. So I know we'll have some questions about that as we go along, but yeah, let's go on to the next. I wanted to go backward one.
The maps?
Yeah, the maps. because this picture doesn't show the, there is this depicted way over here, it's really hard to tell, I've got it on another slide somewhere, is the, what was previously known as the western system plume, and we've got a label on it, which is about 20 times bigger than the actual plume is shown. That's relatively low concentration, in the neighborhood of 100 parts per billion. The company is currently, for a number of years now, has been doing batch purging, which every month they go and they pull out 30,000 gallons of groundwater and they truck it back to their treatment plant for treatment. And the strange thing in this area is that the extraction well, and this is contrary to how things usually work, the extraction well has higher concentrations than all the monitoring wells around it. The extraction well is the only well in that area that's above 85 parts per billion. The company's original proposal didn't even address this area. They were like, well, it's almost cleaned up, so we shouldn't have to worry about it. And we said, no, you either have to keep taking active remediation, or you can get deed restrictions on the properties around that area to prevent people from using the groundwater. Now, all of this area has been hooked up to city water, so people are not drinking the water there.
But to the west, there's a whole bunch.
Yes, and there's another home over a little farther west that is impacted with dioxane. Again, it's below 85 parts per billion. As of right now, we don't have the ability to require the city to address that situation. But, okay, now, Mitch, you can go 2 slides forward on the map. Yeah, okay, so this is the plumes kind of close up on the west. This is Wagner Road again here. This is the Paul facility. And so this area, again, previously had to be fully cleaned up, including the core, and the western system, which because we're now calling this west of Wagner Road the western area, and east of Wagner Road the eastern area, we have changed the name of the western system to the Little Lake area. This is Little Lake, and here this plume shows up a little bit better. I actually didn't know that showed up there. I think I have to go back to the other figure. So the company, now these black dots here, these are all extraction wells. Most of those are in use. I think there's probably 14 or 15 that are currently in use. They have been extracting, although the plumes have not really shrunken as much mass as they have pulled out of there. The plumes are about as big as they were 10 or 15 years ago. Certainly there have been some changes, so the mass is much lower, but the overall size of the plume is about the same. And there is the marshy area over here that has some higher contamination. It's very shallow. That's adjacent to Honey Creek, which is kind of obliterated here by the plumes. So that there are some source areas. Again, the concentrations are much lower now. And so again, the company, Pall-Gelman Sciences, wants to avail themselves of the changes to the statute that allows them to reduce exposures to the contamination and use the risk-based approach. But west of Wagner Road, because we have relatively small number of parcels, instead of expanding the prohibition zone over here, the other method that we use are actual deed restrictions on individual properties. And that, the DEQ prefers that because it gets recorded with a deed. Anybody who buys that property, there was a question about, well, we haven't heard about this. Well, the Prohibition Zone, the original Prohibition Zone, had over 4,000 parcels in it. And there was no requirement that there be a notice sent to every person. I wish that we could have done that, but somehow that was not something that we were required to do or able to do or make the company do. But in any case, so Paul Life Sciences is proposing to continue purging from several of these extraction wells at a somewhat reduced rate. Again, as I said, the combination of all the purging they're doing now is bringing out 500 parts per billion into their treatment system. When this site was first discovered, the areas around the plant here were as high as 200,000 parts per billion. Now, they have cleaned up a lot of it. Again, also some of it has migrated away because, I don't know if I emphasized this enough at the beginning, dioxane is totally soluble in water. So it moves wherever the groundwater takes it. And again, because of the complexities here, the groundwater has taken it in many different directions. And that's why we're still dealing with it, basically, 40-some years later. From when they first started using it. So they're proposing to continue doing some mass removal, and then at some point they will decide, they have to come to us and say, okay, we think we've taken enough out that it's not going to expand. We're going to put in and they put in about 6 monitoring wells in this area. We put another one here, I put one over here. Just in the last few months, we had one surprise, and this plume, I'm sure Raj will point out, does not reflect that new information. But as a result of that higher contamination, we had to put in another well to the south and another well to the west, which were all the other wells except for that one were either non-intact or I think there was just this one new one over here. And so far, we don't have results from the permanent well yet, but the vertical profiling results were in the 6, 10, 12 range. So the idea is they continue moving as much mass as they can, and then they come to us and say, okay, we think we want to turn it off now. We have to approve that. And then they continue long-term monitoring for a minimum of 10 years. I'm guessing it's going to be longer than that. Again, they need our approval to stop doing monitoring. But before they can put on these purge wells, they have to get the deed restrictions, and they have to deal with those property owners individually to get the deed restrictions on those properties. That's something between the two of them, the property owner and the company. But it has to be according to terms in this legal deed restriction that meets the deed use requirement.
Can the company take them to court?
The company can take those people to court, yes,
There you
they
go.
can. Typically, I think, and I'm not a lawyer, but I believe there's typically going to be some compensation expected for that. But that's not something that the DEQ gets involved in. So now we get to the Unit E, which, do I have another slide for this year? Not on the map, yes. Okay, so this is just a little bit of a close-up of this is actually the figure that was attached to the Third Amendment to the consent judgment. In the green is showing the original Prohibition Zone, and in the red is the expanded Prohibition Zone. And then the next slide is a close-up of that area. And we will make this slideshow available. I don't know. I don't know if we put ours on our website, but I believe the CAR group or our presentations have been made available. And this map, the other map is on our website, and we can probably make this one available as well. So that's the area, very densely populated, and we're right here. And then I think the next slide, I meant figure, okay. Now this is the plumes all combined, and this is the western portion of the original Prohibition Zone as well as the expansion. And there are, again, not all the monitoring wells are shown. And then the other,
We're going to need additional monitoring wells in the new prohibition zone? I know
They've
there was
actually
discussion
already
about-
installed them. They put one, well, they put one more interior that we wanted, and then they put.
The question was asked, are there going to
Sorry.
be additional wells installed in the new prohibition zone, and Sybil's responding to that.
Right, and they've already installed them, and I think, I forget exactly, there's one back here, and I think there's one over here, and then there was one interior. All three of those came back non-detached, and then there's going to be a fourth one, we think, in this area. Yeah, we wanted to get to this slide too. So.
Sybil, can you just stop for just a second?